Court is calling 2015 CR 1686A, State of Texas versus Selena Ann Pettis. Can I have parties announced for the record for the state?
Hank Wilkins for the state.
Right from the opening call of the docket, we already know this is serious. This isn't a brand new trial. This is a probation revocation hearing. And those are often more dangerous for defendants than trials themselves. Selena Perez had originally received deferred adjudication, which is basically the court saying, follow the rules and we won't formally convict you. But now the state says she violated probation by failing to report for 3 months. That may sound minor to some viewers. But in the probation system, reporting is everything. It's how the court ensures someone is staying on track. The moment she admits the violation, the judge gains full authority to enter a conviction and impose a severe sentence, even life in prison under the original drug charge range. And already, the emotional tension starts building. Selena later explains family pressures pulled her away, but the judge will challenge whether that was unavoidable or simply a decision. So here's the question for you watching. If family emergencies clash with legal obligations, what should come first, survival or compliance? Stay tuned because Judge Boyd is about to deliver a courtroom lesson people won't forget.
Defense?
Brad Thornton for defense.
And are you Selena Ann Pettis?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Selena Ann Pettis who was placed on deferred adjudication in 2015 CR 1686A for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams on August 31st, 2015 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5. In Bexar County, Texas, the defendant Selena Ann Perez did then and there fail to report to the supervision officer for the months of February, March, and April 2019 in violation of condition number 5.
Is that true or not true?
That is true.
Your Honor, we waive and abandon the other violations.
Any objection?
No objection.
This short exchange carries enormous legal weight. When Selena answers true, she eliminates any need for the prosecution to prove the violation. No witnesses, no evidence battle, just admission. And here's the legal reality. Probation is conditional freedom. Courts expect strict compliance because probation officers monitor behavior, drug testing, employment, and public safety risks. Selena later explained she was helping her daughter who had just given birth. Many families watching can relate to stepping in during difficult moments. But from the court's viewpoint, the issue isn't helping family. It's failing to communicate with probation. One phone call could have changed everything. The judge now shifts the focus toward accountability. And coming next is one of the strongest teaching moments in the hearing, where Judge Boyd explains the difference between a mistake and a choice. Let me ask viewers, have you ever avoided a responsibility out of fear, only to make things worse later? Because fear plays a huge role in what happens next.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to life in prison and up to $10,000 fine?
Yes, ma'am. I understand.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court's going to find violation of condition number 5 true. Counsel, I need you to fill out the trial court certification of defendant's rights to appeal form. Oh.
Sorry about that.
Oh, no problem. All right, is there a proposed agreement?
There is, Your Honor. We are asking you to find the defendant guilty, and the state will take into consideration cause number NM 720021 and sentence the defendant to 5 years TDC.
All right, cause number 720021.
Yes.
What is that charge?
That's possession in a possessing a prohibited substance in a correctional facility.
Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
In defense, is this the agreement?
It is.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Selena Bettis.
All right. Why are you not reporting for probation?
I just had some, my children, my daughter had a baby and I had to help her because of,
How does that exclude you from being able to pick up the phone and report to probation?
I made a mistake, ma'am. I understand that I made a mistake. That's why I'm willing to.
Nope, you didn't make a mistake. You made a choice. Let me explain to you what's the difference between a mistake and a choice. Let's say I come to court. I have a black umbrella because it's raining outside. I know it's going to rain outside. The person sitting next to me has a black umbrella. And when I leave the court, I grab my umbrella because I know it's raining outside. I go outside. I open the umbrella to protect myself from the rain. And I look underneath the umbrella and my initials are not there. That's a mistake. I mistakenly took the wrong black umbrella. Let me tell you what a choice is. I don't know it's going to rain. My mom hasn't called me and said, Stephanie, it's going to rain. Be sure to take your umbrella.
Judge Boyd's umbrella analogy might sound simple, but it hits deep legally and emotionally. She draws a sharp distinction. A mistake happens accidentally, but a choice involves awareness. Courts tend to forgive accidents. Choices carry consequences. Selena initially calls her failure to report a mistake, but the judge pushes her to acknowledge it as a decision, and accountability matters in sentencing. Notice something important too. The judge isn't shouting, she's teaching. Many viewers see tough judicial questioning as harsh, but judges often try to make defendants understand responsibility before final decisions are made. Still, Selena is clearly afraid. Ironically, fear of court kept her from reporting, and that fear brought her right back into court anyway. So let's ask, do people sometimes sabotage themselves trying to avoid consequences? Because what happens next shows exactly how costly avoidance can become.
And I come to court and I'm sitting next to somebody who has an umbrella and people are saying, ooh, it's raining outside. And I say, curses, I don't have my umbrella, but I don't want to get my hair wet. And I just take somebody's umbrella and I go outside. You know what that is? That's a choice. That's not a mistake. So you didn't make a mistake. You made a choice. So why did you choose not to report to probation?
May I speak with my attorney, ma'am?
Oh, sure. Yes.
Sorry, ma'am. I'm scared. I was scared at the time, same as I am right now.
Okay, you're whispering and I can't hear
I
you.
said I was scared at the time, same as I am right now.
Scared of what? You were supposed to report. So
Yes,
what are you afraid of with reporting?
of being back here.
That makes no sense to me. If part of your conditions is for you to report, you report.
Yes.
So what is the fear of reporting?
I don't have a fear of reporting.
All right. All right. Is there anything else?
Ma'am.
Has she done anything on probation? Have you done anything on probation?
Done some, yes, ma'am.
What have you done?
I mean, I know it doesn't show like as far as the narcotics, but the classes, but I did do some of the classes. I did need to do the community service, which, I mean, of course, I know it's not an option at this point, but I was willing to do probation and whatever I needed to do.
So what classes are you saying you've done?
Just the Narcotics and Alcoholics Anonymous.
Oh, so you've done AA meetings.
Yes, ma'am.
Program. She's supposed to. The programs that were listed originally, no, none of those were completed.
Okay. All right. This is what the court is going to do. The court is finding violation of condition number 5 true. The court will find you guilty. The court will sentence you to 8 years in the prison and give you credit for any time served. And taking consideration.
And here it is. Sentencing. 8 years in prison. Notice something critical. Although discussion earlier mentioned 5 years, judges are not automatically bound by agreements unless formally accepted. Judge Boyd retains full sentencing authority. This shows the danger of revocation hearings. Once deferred adjudication is revoked, sentencing goes back to the original offense severity, not just probation violations. However, the judge still offers referral to the therapeutic community program, a treatment-focused prison unit aimed at addiction recovery. That's an attempt at rehabilitation within incarceration. Emotionally, this is devastating. Family responsibilities pause. Freedom disappears. But the judge's message is clear. Responsibility ignored leads to serious consequences. So here's a tough question. Should drug-related offenders receive more treatment options instead of long prison terms? Because the next case shows how different choices can produce very different results.
Nightmag number 720021. If you would like, I would have you recommended for the therapeutic community. It doesn't increase the time that you're in custody, but they will be able to help you with any drug issues you say that you have. Would you like the court to refer you for that?
Yes, ma'am.
All right, and I'll ask for the therapeutic community. However, I have no jurisdiction to force them to place you in the therapeutic community, but they most definitely will not place you in the therapeutic community if you do not ask for it. All right, going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes.
You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Do you understand?
Yes.
All right, we can go off the record. You're going to have to do better with your life. Otherwise, you're going to continue to be back here. All right. And I'm sorry, one more thing on the record. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. You understand?
Yes, ma'am.
All right, good luck to you. Do better.
Thank you.
2020 CR 5322C, State of Texas versus Angela Gonzalez. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense,
Larry Bloomquist for the defense.
are you Angela Gonzalez?
Yes, ma'am.
Showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Are you the same Angela Gonzalez who was placed on community supervision in 2020 CR 5322C for the offense of robbery on November 19, 2020 for a term of 5 years? Is that you?
Yes, sir.
State?
Violated condition number 1, on or about the 31st day of March 2022 in Bexar County, Texas. The defendant, Angela Gonzalez, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objections to the waivers?
No, Your Honor.
All right. Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, sentence you up to 5 years in prison and up to $1,000 fine? Did you understand?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes,
Can't
we do.
hear.
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, is to continue the defendant on probation to add a no contact order with the victim in the assault case.
Now we move to Angela Gonzalez's case, and already the tone feels different. Angela also violated probation by committing assault, which is serious. But probation officers report something Selena didn't have: progress. Angela completed programs, earned her diploma, and maintained compliance for extended periods. Courts evaluate overall patterns, not just isolated mistakes. Context matters too. The assault occurred during a school fight involving someone she considers family. Not justified, but emotionally understandable. Judges weigh whether probation is working. Angela shows signs of improvement, stability, and parental responsibility. So now suspense builds. Will Judge Boyd revoke probation again, or give Angela another chance? Angela's testimony coming next becomes the emotional turning point.
To add in anger management and MRT, and she's also going to take the plea in the misdemeanor case. They're going concurrent with this one. And that's County Court Cause number, sorry, I had it in front of me. 709518.
All right. Probation. Has she done anything on probation other than commit a new offense?
Yes, Your Honor. Her UAs, for the last year at least have been negative. There's been a couple of diluted. She did finish the outpatient program. She completed her parenting class. And she did obtain her high school diploma.
All right, what is this assault about?
Judge, there was there's her boyfriend's daughter, who she is, her boyfriend's sister, who she is right now my client, her primary caretaker. She was involved in a fight at school, and my client, instead of breaking up the fight, she did punch that young lady. And I think that
So students are in a fight. She goes to the school and
there were some parents trying to break up the fight, and my client starts to try to break up the fight, but loses her cool and punches the young lady.
and when you say young lady, are we talking about a child?
I would guess, yes. I don't know her exact age. I think she's about 15 years of age.
Okay.
And what I would just tell the court, and if you want me, I can call my client as a witness.
Yes, let's do that.
Okay, let's do that. Can you raise your?
Sure. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
You can lower your hand if you state your name for the record.
Angela Gonzalez.
All right. So what have you learned since you've been on probation?
Honestly, Judge, I learned a lot. I'm glad that you put me on probation the first time. I was able to get my diploma, and I actually got better jobs within the years that I've been on probation because of my diploma. Because of you, I'm able to see my other two kids that originally the kids' grandma wouldn't allow me to. We have a better bond. I get to see them every Sunday.
This is where probation's purpose becomes visible. Angela explains how supervision helped her rebuild relationships, improve employment, and reconnect with her children. Probation isn't just punishment. It's supposed to help people rebuild their lives. Education, sobriety, parenting responsibility. Judges look for these signals of change. But again, accountability remains key. Judge Boyd reminds Angela this incident was still a choice, not an accident. And viewers can see the emotional difference between someone trying to improve and someone overwhelmed by fear and avoidance. So let's bring you into the decision. If someone shows real growth but slips once, should the court erase progress or support continued improvement? Because the judge's ruling next answers that question.
And she lets me take them to the park, to sit with them and be with them birthdays, holidays. That's something that I didn't have before you put me on probation, and I really want to say I do appreciate that. Right now, I did learn a lot. Just me having to take care of my sister-in-law as well, it made me grow up a lot just because my husband's mom suffers from seizures and strokes. So that put me on a higher level to where I need to be focused on my kids. It's not about anything else but my kids. I want them to have a better life than what I'm going through right now. They don't deserve for me to be here and then me missing out of their lives on all four of my kids. I just recently had a baby. He's 9 months. So I mean,
Who's with your baby now?
My sister's friend's mom. She's helping me babysit right now. So I mean, I just hope that you see that I did learn from this past years. I've been coming out clean again because of you, Judge. I stopped smoking. And it honestly, everything just bettered my life. And this was an honestly mistake. I did went to the school and I did talk to the principal.
Not a mistake. It was a choice, right?
A choice, my bad. I did talk to the principal. I tried to have a meeting with the other girl's mom. And like I said, at the time I was pregnant, it was a choice, not a mistake.
And let me just clarify that, Judge. Can I just ask you one question
No,
about that?
let me
Okay.
hear. Yes.
The school was just not taking that step to where she had to walk out of school campus to come home crying to us. We sent her back home thinking it was going to be the right thing, but turned out to be not the right thing. In my opinion, I should have just left her home and none of this would have happened. And I messed up. I honestly did, and I just hope that you could give me a second chance and let me prove you and everybody wrong.
And the point I wanted just to make clarify for the judge is, Your Honor, she had actually reported that her daughter, or the girl who she considers her daughter, was being bullied after school by these several girls. And she had been reporting that to the school and they hadn't taken any action. And unfortunately, I think one thing I just tell the court is I've had extensive conversations with Angela. She's an extremely great person. She's made some bad decisions. And one of the things that I've been talking to her about is her need to make better decisions. And she's doing a lot of great things. Unfortunately, she had this horrible decision that she made that's put her in front of you. And I can tell the court, I feel like she's very, very remorseful for what's happened. I think she's realized that not only has she put herself in peril, but she's put the kids that she's caring for.
What steps have you taken with the school?
She doesn't. She longer doesn't go to that school. It was a middle school. I just enrolled her in Highlands High School.
Okay.
So I mean, right now that school is out of my. I will never put my kids in that school just because they don't know how to take steps on how to protect their students.
All right, State.
So Judge, we were able to talk to the complainant in that case's family. It was very difficult getting a hold of them, but we were able to do that earlier this morning. I did explain what our options were. They did indicate that they were okay with this approach. I told them exactly what I was going to do. I don't know any of the claims of bullying. None of that came forward through the police reports or anything that we had available. So I can't substantiate that.
All right. So this is what the court is going to do. Court will deny the motion, alternate amend conditions, probation, either anger management or MRT, not both. So whichever one probation feels would fit best for her, that's the one we'll go with.
And here comes the contrast. Judge Boyd denies revocation and keeps Angela on probation, adding anger management or MRT treatment. Why? Because probation officers confirm progress and Angela shows responsibility improvements. This shows judges don't just punish, they assess future risk and rehabilitation potential. Angela leaves court free but under warning. Future violations may lead to prison. The courtroom energy shifts from tension to relief. Here's the debate question. Was Angela treated fairly compared to Selena earlier, or should consequences have matched? Two cases, same judge, completely different outcomes, based on choices and progress. Let's close this out.
All right. Is there anything else you need from the court? Well, I mean, I'm asking her. I hope you don't need, do you need anything else from me, counsel?
No, I apologize. I wanted to thank the court because I believe that she's going to do well. And I think that I just want to thank the court.
Oh, you're welcome. Well, based upon what probation is telling me, she is doing well. So you need to continue doing what you're doing. You understand?
Thank you so much.
Is there anything else you need from the court?
I promise you won't see me again.
Judge,
All right. Well, I can see you again if you completed everything and maybe you want to get off early. Yes.
Judge, I was just going to ask for that no contact order.
All right. And who's the complainant?
Her name is Victoria.
All right. So you're not to have any contact with that complainant. You understand?
Yes.
Only other thing, this is just a run concurrent with the misdemeanor case.
Yes.
All right.
And I'm going to make a schedule, Judge, to get complete on that as soon as possible.
All right. What is the cause number in that?
That's CC 709-518.
508?
518.
18. And state, we're off the record and state that you informed them downstairs what their plea should be?
So I did put a note in the system, exactly the details of the length of probation, the type of probation, the other conditions. I did say standard conditions, so they should know what to do.
All right. Thank you.
Thank you,
Thank
Judge.
you so much. You have a good day.
You too.
Today's courtroom session showed two paths under the same judge. Selena Perez's repeated probation violations resulted in an 8-year prison sentence. The court emphasized accountability and consequences. Angela Gonzalez, despite committing a new offense, demonstrated rehabilitation progress through education, parenting responsibility, and treatment completion. Judge Boyd determined probation was still effective and allowed her another chance. The lesson? Courts examine behavior patterns, effort toward change, and future risk, not just single incidents. Judge Boyd consistently emphasized one message: choices matter. And now we want your take. Which outcome felt fair, and what decision would you have made as judge? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.